Trademark legal, baby. Watch it, learn it, keep it, work hard at it. Trademark resource, babe. Watch it, learn it, keep it, work hard at it. Trademark resource, babe. Watch it, learn it, keep it, work hard at it. Trademark resource, babe. Watch it, learn it, keep it, work hard at it. Trademark resource, babe. Watch it, learn it, keep it, work hard at it. Trademark resource, babe. Watch it, learn it, keep it, work hard at it. Get it, Quill? Who be the king of the law? Every time. Thank you so much for joining us today. I am Marquel Cade with Cade Mark Law, your favorite neighborhood lawyers, back with another resource for you. Every once in a while, I have a prospective client come to me saying, Marquel, I need help with a divorce. My spouse doesn't oppose the divorce. We actually both want the divorce. Can you help me file the proper paperwork? This is what's called an uncontested divorce. And uncontested divorces are very simple and even more easy and simple when there aren't any children involved or any assets to divide. Uncontested divorces are when both parties are agreeing to the divorce, whereas a contested divorce is where the parties are fighting over some aspect of the divorce. Maybe they both want to be divorced, but there is some fight over the parameters of what's being divided when it comes to marital assets. There's some fight over children. There could be some fight over a combination of both. But contested divorces typically take this route. There's a fight between the parties, maybe not over the divorce itself, but over the particulars of the divorce. In uncontested divorce situations, it's very easy to get a divorce because both parties already agree on everything in most instances. So today, we're gonna talk about the 3 steps to filing and completing an uncontested divorce. Disclaimer alert, each jurisdiction, in this case, each state, is gonna have its own laws on divorce because state law typically governs divorce proceedings. This means you're gonna wanna consult with a lawyer in your state, a lawyer in your area, or a lawyer who's familiar with your state's laws when it comes to filing uncontested divorce proceedings. There may be an additional paperwork to file in your jurisdiction. There may be less paperwork to file in your jurisdiction. There may be paperwork that's called different things from jurisdiction to jurisdiction. You just want to check with the laws and lawyers in your state on what you need to file for your uncontested divorce. This won't be a guide for every state. This will just be a guide to generally get you through the process. Step 1, work with your soon-to-be spouse or ex-partner to complete the petition for divorce and initial court filings requested by the court for an uncontested divorce. Usually, this includes what's called a petition for the dissolution of marriage. Now, usually these court filings include everything that you and your spouse have about your marriage. They'll include your date of marriage, your date of separation, the reason for separation, any agreements that you have already pertaining to child custody, pertaining to marital assets. These things will be outlined with the court in your initial filings. And usually, when you're done drafting them, both you and your soon-to-be ex-spouse sign them together so that you can file them with the court in a joint petition. Now, it's okay if you don't have your spouse's approval or help or input with step 1, because you can file these documents solo. In those instances, you typically also must complete the notice and the summons of this petition, which means that you must give the copy to your soon-to-be ex-spouse. What you're filing with the court must be provided to them beforehand, or at least within a certain time frame after you file it with the court. But you'll want to complete these filings whether you're filing them with your spouse or you're filing them solo. Step 2, after you've drafted and filed your initial filings with the court, your petition for the dissolution of marriage, and the other filings that typically accompany that, you're gonna want to attend your initial status conference with the court. Typically in divorce proceedings, the court will set a hearing shortly after the parties have filed their initial filings as a way to get the insight into the case. They go over everything from what date were you guys married, to where you were married, to when you separated, to when you decided to get a divorce, to why you decided to get a divorce, to everything that you've agreed upon as it relates to custody and marital assets being split. They'll basically go over the details of your case in the initial status conference to ensure that everything that you put on your court filings is correct. Step 3, attend your final divorce hearing or wait for an order from the court granting your divorce petition. In some instances, the court doesn't need to have a hearing, and they'll simply grant your petition for divorce, and you'll receive a court ruling that states that you've now been divorced from your spouse. In other instances, the court wants to have a hearing just so that they can see both parties, just so that they can make sure that there aren't any lingering issues, or maybe to absolve any lingering issues that may have recently come up after the filings have already been completed. In instances of a hearing, typically both sides will plead their case, and then the court will make a determination on the divorce. They'll make a determination on custody if custody is an issue. They'll make a determination on spousal support if spousal support is an issue. They'll make a determination on the division of marital assets if that is an issue. But usually at the hearing, the court resolves any outstanding disputes between the parties and then grants the parties their divorce. Fun fact, as an added bonus, the court can also restore a party's maiden name in a divorce proceeding or hearing. If a party requests that their last name be restored to their maiden name, the court order granting the divorce can also make a determination as to this. It can restore a party's name from their married name back to their maiden name, which allows them to take this court order to the DMV, to the Social Security office, to the State Public Records office, and get a new birth certificate, and get a new Social Security card, and get a new driver's license, a new bank account card, and all of these things can be accomplished through the court order of a divorce determination. But generally speaking, after step 3 has been completed, congratulations, you have now gotten a divorce. Now, uncontested divorces are a lot easier than contested divorces, as parties fight over every single little issue, and it takes an experienced family lawyer to help you navigate these issues. So don't use this guide if you and your spouse or soon-to-be ex-spouse are going to be fighting over things like child custody or spousal support or marital assets. Because in those instances, when you're fighting over those things and they don't come up after you've already filed for an uncontested divorce, you have a contested divorce. You don't have an uncontested divorce, and this guide won't be helpful for you. That's all, folks. Thank you so much for joining us today. This has been 3 steps to getting an uncontested divorce. We hope this was helpful. Once again, I am Markwell Cade with Cade Mark Law, your favorite neighborhood lawyers. Protect your brand, grow your business. Stay frosty, my friends. We'll see you next time. We hope this was helpful.